Hello everyone, I'm Anuj and I'm a legal intern with LEXIS and Company, and this is the second part of the video, and the topic was separation of power. So, doctrine of separation of power is based on basically four principles, which is exclusivity principle, which suggests structural division of all the three organs of the state. Next is functional principle, which prohibits amalgamation but not interaction of the organs. Next is check and balance principle, which states that each organ of the state may check the other to keep it within constitutional bounds. And the last one is mutuality principle, which is cooperation and not confrontation. So separation of power in practice is can be taken example as the USA. The doctrine of separation of powers finds its home in the US. It forms the basis of American constitutional structure. Article 1 Section 1, which vests all the legislative powers in the Congress. So Article 2, which Section 1 vests all the executive powers in the President of the United States. And lastly, Article 3, Section 1 vests all the judicial power in the Supreme Court. The framers of the American Constitution believed that the principle of separation of powers would help them to prevent the rise of tyrannical government by making it possible for a single group of persons to exercise too much power. So accordingly, they intended that the balance of power should be attained by checks and balances between separate organs of the government. So this alternative system existing with the separation doctrine prevents any organ to become supreme than the other. Further, in England, a separation of powers is the purest form is not of the purest form and never has been in feature in functioning of the organs of the government of UK. Since UK has no written constitution, so there is no written document regarding this matter also. An examination of the three powers reveals that in practice they are exercised by the persons or the bodies which exercise more than one such power. So it is the position of Lord Chancellor which is the most commonly cited in support of the argument that there is no separation of power in the UK, as the office of Lord Chancellor has existed for many centuries and occupies the unique position as the incumbent. Incumbent is a member of all three branches of the government with dominating powers in the hand. The judges exercise also executive function under the Trust Act and also legislative functions in making rules of courts regulating their own procedure. House of Commons also exercises judicial functions in cases of breach of its own privileges. So the situation in India is that articles reflecting the separation of powers are Article 50 of our constitution is separating the judiciary from executive, as the state shall take steps to separate judiciary from the executive in the public services of the state. Article 105, which talks about powers, privileges, etc. of the houses of parliament and all the members and committees thereof. And Article 121 talks about restriction on discussion in parliament, which states that no discussions shall take place in parliament with respect to the conduct of any judge to the Supreme Court or of a high court in the discharge of his duties, except upon a motion for presenting an address to the president praying for the removal of the judge as a hereinafter provided. Article 122 of the Constitution talks about that the courts not to inquire into proceedings of the parliament. So further, Article 211 talks about restriction on discussion in the legislature, which is that no discussion shall take place in the legislature of a state with respect to the conduct of any judge of the Supreme Court or of a high court in discharge of its rules or his duties. So there are also various provisions which are challenging to the separation of powers. which can be executive as by legislative powers. Article 123 of the Constitution, which talks about power of President to promulgate ordinances during recess of Parliament, and similarly Article 213 also, and Article 111. Article 356 talks about provisions in case of failure of constitutional machinery in the state. If the President, on receipt of a report from the governor of the state, or otherwise satisfied that the situation has arisen in which the government of the state cannot be carried in accordance with the provisions of this Constitution, the President may be proclamation. So this was the doctrine of separation of power, and I hope I was able to explain to you guys the brief concept about it. Thank you, everyone.